Good evening, everyone. I am Harshamud, the student convener of Center for Legal Aid Program, NUSRL Ranchi. On behalf of the organizers, Center for Legal Aid and Pro Bono India, I welcome you all to the 12th day of short-term course on legal aid and allied laws. Yesterday, we had an insightful session with Professor Dr. Ashokar Patel on the consumer protection, where he explained the role of law students as to how they can help in the redressal mechanism. Today, for a session on human rights, we have with us Dr. Mohammad Umar. Sir is an accredited mediator from India and is the founder advisor to the Center for Peace, Justice, and International Law. He also teaches international law and ADR as guest faculty at the University of Lucknow and holds a PhD in international wildlife law from the Center for International Legal Studies, JNU, New Delhi. Previously, Sir also taught at the Bennett Universities and Galgotias for 7.5 years. Sir is a gold medalist in post-graduation and has published in diverse areas. He has also been invited to speak at several institutions, including the London School of Economics and Political Science, the Hidayatullah National Law University, Raipur, GNLU Gandhinagar, Rajiv Gandhi National University of Law, Patiala, Aligarh Muslim University, and the Indian Society of International Law. He is on the editorial board of the Journal of International Law and Comedy and the Journal of Law and Religious Affairs, and has reviewed several reputed journals as an external reviewer, having widely written for prominent media houses like the Indian Express, The Wire, First Post, amongst various others. Sir is registered with the Singapore International Mediation Institute as a level 1 mediator and is co-investigating the research project concerning access to copyrighted works for visually impaired persons. We welcome you, sir.
Thank
Please
you.
begin with the session.
Thank you so much. And thanks to Kalpesh ji for inviting me to this event. And the collaboration between Pro Bono and NUSRL is quite a welcome collaboration. And I could clearly see the list of the panelists who have spoken and the kind of exchanges. I can only imagine the wonderful exchanges that have taken place till now and would happen in the forthcoming sessions. So, first of all, let me just confirm I am audible and visible to you on the screens, right?
Yes, sir.
Okay, great. Chalo. So, so Kalpesh has given me a very difficult task of engaging with something as amorphous as human rights. So, this is something which is to be taught uh, in a semester or in a year. There are 2 year LLMs happening in human rights. So I don't know how much of justice I would be able to do in these few minutes that I have got to share with you. Now, so broadly, we will divide it into two sections. One, I would like to touch upon the human rights as a hard bargained asset. Right. I'm not going to teach you about what are the fundamental rights or what are the relationships between the fundamental rights or the directive principles, because this is something that you don't just read in your law schools, but also you read it while preparing for the law school. So there's no point in going through them, because that is something very fundamental. But maybe we will try to uh, have a look at the trajectory of human rights as a claim, how that works, and what has been the history of major human rights that have been, claimed by various communities and individuals and groups over the period of time. And maybe sometime at the end of the session, we will also think, and I'll pose a question to you, maybe in the direction that why is it that it is so hard to struggle? Why is it so hard to claim a human right? even in democracies, right? And why is it that there is no uniformity in the conduct of democracies when it comes to the granting of human rights, right? We have seen the abortion right getting flipped in the United States of America very recently. So we will try to see how all of that works out. So first part of the discussion would be relating to the bargaining of the human rights. The second part would be dealing with the international legal character of human rights. Because for those of you who have read jurisprudence, you would know that how the international law informs the domestic law, and especially in the sense of human rights after the coming of the United Nations and the Universal Declaration of Human Rights. How many states have imbibed those principles within their domestic jurisdictions, and just in case if they don't practice it, they are still expected to follow them, either as an international legal obligation, or as a matter of being a part of the civilized community in the United Nations. So these are the two sections that we would try to engage with in the discussion. So first of all, let me just ask you one very simple question. Have you heard about the social contract theory? If you have heard, then you can just let me know what is it. Uh, uh, can I uh, can I just request the moderator to put it in a gallery mode so that I am able to see some faces, because I am not able to see anyone. If that's a possibility, otherwise that's fine. I can simply go ahead. Can we put it in a gallery mode? Is it a possibility?
No, sir, it's not really possible.
Oh, okay, no issues. Chalo, but people can respond when I'm asking them the questions, right?
Yes, sure. They can raise their hands and we can unmute them.
Yes. Okay, great. So tell me, people, that have you heard about the social contract theory? What is it? And what do you understand by it? Anyone? Come on. It's a simple question. Okay, so we have some responses by, let's say, uh, Anukul and Aparna. Aparna, can you, or Anukul or Satyam, can any one of you just raise your hand and tell me what have you read about it? What do you vaguely remember about social contract theory?
Sir,
People live in the society in accordance with some agreement. यार हम लोग थोड़ा और इंटरेक्टिव हो सकते हैं क्या? चैट वैट तो बहुत फॉर्मल हो जाता है. Is it
sir,
possible that I get a response either vocally?
am I audible, sir?
Miss Aparna, yes,
Yeah, sir.
yes, you
I
may go
think
ahead.
according to this theory, they said that the society came into a contract, and they said that like these leaders will lead us. But the criticism of this theory is that no such contract was found.
Okay, okay, so that's one perspective. So, social contract theory is basically accredited to, if you have read jurisprudence, to the trilogy of Hobbes, Locke, and Rousseau. It basically implies that people come together in an agreement to establish some political and moral rules of conduct, that these are the broad rules that we would stick to as a society, as a community, as a nation, let's say, right? So social contract theory is that kind of a political and moral arrangement between the communities, between individuals, between the individuals and the groups and the state, right? So that is what we really mean by the social contract theory. It's no time to go into the detail of it, but can you tell anyone other than Aparna? Can you tell me the document that reflects the social contract of India? Anyone? Yes, 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 Sohail, you're correct. Ankit, yes, Constitution of India. So, Constitution of India में specifically बताओ which part of the Constitution of India establishes a robust social contract? Yes, yes, yes. So you got a sense of it, right? So in the preamble of the Constitution, we have declared ourselves as a socialist, secular, democratic republic that would ensure justice, liberty, equality, and fraternity for the people. These are the broad political and moral rules that we have given to ourselves, right? We the people of India, giving to ourselves. So, so that is our social contract. And when we talk about justice, equality, liberty, and fraternity, the four preambular values that we have in the Constitution, we have found some ways of enforcing those values. And of course, one of the ways of enforcing those values is, litigating under Part 3 of the Constitution and asking the court through the writs under 32 or 226 to give us our rights that are constitutionally recognized. If they are already so explicitly recognized, the next question is, why is it that sometimes it becomes a little not a little, in fact, a lot difficult to claim something which is rightfully ours? Why do we have to struggle to get our human rights intact in established democracies? Right. So there is one scholar from the University of Birmingham. His name is Mohammad Shahabuddin, and he is an international law scholar. So he has basically talked about the post-colonial state. All of you know that what is the colonial times. Colonial times are those times when we have been occupied, we have been under the colonial rule of the British. It has been one of the darkest eras in our history. The kind of loot and plunder, all of that happened. But then we got freedom, and now we have a post colonial state. कॉलोनाइजेशन के बाद का हमारा एक एस्टेब्लिशमेंट बना. So that post colonial state has three dimensions. It has a nationalist dimension, it has a liberal dimension, then it has the developmental dimension, right? So the post colonial state is working on an ideology, right? And that ideology can be a nationalist ideology, it can be a liberal ideology, or it can be a developmental ideology, according to the scholar that I have just quoted, or it can be a mix of all three. So a nationalist ideology would be that there is a certain idea of nation and the people of nation, and everyone should adhere to that idea. And let's say when we talk about the liberal part of the post-colonial state, the liberal part of the post-colonial state essentially sticks to treating the population as citizens of a particular nation, right? When you talk about citizens, your other identities are dissolved. Let's say you are a citizen of India, but you are also a Sikh, you are also a woman, you are also maybe having a sexual orientation which is not a heterosexual orientation. So you have different identities attached to you, not just that of a citizen. But the liberal post-colonial state actually tells you that you are supposed to be a citizen in the typical political sense of the term. The third part of this engagement is the developmental part. Okay, you put so much of development as a currency before the population that the claim for human rights somewhere get dissolved. The claim for human rights somewhere gets lost, and you are more inclined towards, you know, uh, you are more thinking about the developmental aspects instead of your right as a citizen. So these are broadly three ways in which the post-colonial state has behaved over the period of time. That's the experience of the international legal scholars. Let us come to India and let us see how has been the struggle for the claim of human rights in India over the period of time. I have picked up some cases for you, and maybe those cases would be sufficient to convey the point that I am trying to convey over here. So the first case that I want to discuss with you is Indira Sahni versus Union of India. Right. So uh, let me just share the screen with you so that you get some idea about it. I'm allowed to share the screen, I believe.
Yes, sir.
Can you see my screen on your screens?
Yes, sir, it's visible.
It's visible. Nice, 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 nice. चलो, तो कोई बताएगा इसमें क्या हुआ था? Anyone can tell what is this case famous for? It's a landmark case. और जिन्होंने कॉन्स्टिट्यूशन पढ़ा है, they would all of course know about it. They should know about it. What is Indira Sahni versus Union of India? What did it do? क्या हुआ था इस केस में? Okay, creamy layer, reservation. Yes, you got it. Reservation up to 50%. Fair enough. So this is one of the. Thank you for your responses. I got it that you have understood it. So Indira Sahni versus Union of India is the landmark case with regards to the reservation, right? And reservation is justified on what basis? On the basis of affirmative action. If you have read Ambedkar, Dr. Ambedkar's main idea was that you should get educated, and you should organize yourself, and then you should agitate. When we talk about reservation, we essentially talk about the caste oppression, the caste-based oppression, and the historical oppression, right? So it has taken a good amount of years, maybe let's say thousands of years, to come to a point where we have evolved as a civilization to the extent that now we can talk about doing an affirmative action in favor of the oppressed caste, right? So let me just quote the 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 paragraph from Indira Sahni case. I am not here to discuss the ratio of it. My point over here is, please remember that we are talking about the struggles to claim the human rights over the period of time. Let me take you to the relevant paragraph. I think the paragraph number is 281. Moderator, can you confirm if if you can see the highlighted portion?
Yes, sir.
Yes. So would it be possible for you to read this paragraph?
Sure, I will.
Mm-hmm.
The basic policy of reservation is to offset the inequality and remove the manifest imbalance, the victims of which, for bygone generations, lag far behind and demand equality by special preferences and their strategies. Therefore, a comprehensive methodological approach encompassing jurisprudential, comparative, historical, and anthropological conditions is necessary. Such considerations raise controversial issues transcending the routine legal exercise because certain social groups who are inherently unequal and who have fallen victims of societal discrimination require compensatory treatment. Needless to emphasize that equality, in fact, or substantive equality, involves the necessity of beneficial treatment in order to attain the result which establishes an equilibrium between two sections placed unequally.
Right. So I think it is quite clear that the basic impetus of the policy on reservation is to offset the historical inequality that has been practiced by the bygone generations, right? And so that was the main impulse. And of course, as you would know, that a lot of discourse on reservation is still contested. Some people are not very happy with the way implementation of reservation is happening. They have a perspective, but then there has to be some way to undo the historical problematic that has occurred in the Indian society over the period of time. So that is one example. I want to share some more examples with you. Let us talk about the Shaira Bano versus Union of India case of 2017. Can anyone tell me what was this case, Shaira Bano versus Union of India 2017? Not Shah Bano, please remember, I am talking about Shaira Bano versus Union of India. Yes. This is a triple talaq case, and basically the divorce being pronounced in a single sitting thrice, and the divorce happens. That was the main thing that was contested. There has been so much of a struggle within the Muslim community as far as the women group are concerned, as far as the groups that even if they are not women, but they sympathize and they want to collaborate with the women groups when it comes to the striking down of the triple talaq. The case did not happen overnight. There has been a long standing struggle over the period of time till the time it reached to Shaira Bano case. And if you remember that Shaira Bano case was one of those cases where the judges were quite divided by 2-2-1 ratio. I would like to emphasize on the way the court treated this particular judgment. So one thing was that court was very clear that this is something which has to go. It does not make sense. It is illogical. It is not according to the constitutional parameters. Justice Kurian Joseph, if you will read his judgment in the Shaira Bano case, he said that this practice is fundamentally discriminatory against the women. It is violating their dignity. It makes no sense. And most importantly, it is not sanctioned by either the constitution or the religion. Right? So, and then he quotes the primary sources from the Indian laws, from the religious laws, and then he comes to a conclusion that looking at these two laws, it becomes amply clear that there is no legal basis of this practice. It is just a societal issue. But it took so long, despite the Shariat Application Act coming in 1937 and 1939, dissolution of Muslim Marriage Act, all of those things coming up, it still took so much of time for Muslim women to finally have it heard by the Supreme Court, and Supreme Court saying that any divorce happening through the triple talaq method is not a valid constitutional method. It won't be considered as a divorce. Right? So there has been a long-standing struggle, and it's just that it's a matter of pronouncement. And of course, the next question that I want to ask you, looking at these two judgments, let's say one judgment is on caste, the other judgment is on Muslim women. My question to you is, and you can respond in the chat if you want, that do you really think in your assessment that there is a good representation of Dalits or of the lower caste people in the government sector, in the judiciary, in the educational institution? Right? So despite the reservation, sometimes there are not enough takers. The educational and social background is so weak still that despite having those opportunities, they are not able to avail it. The another question that I want to ask you is that can you tell me whether after the pronouncement of the Supreme Court in the Shaira Bano case, and then of course when it comes to the Triple Talaq Act, as we called it, and it criminalized the Triple Divorce Act, has triple divorce stopped, or it is still a part of the society? It is still practiced. right? It is still practice. It is still, I mean, sometimes if, let's say, it occurs to the woman that I should file a criminal case, then she files. Otherwise it's a religious, it is passed off as a religious law, and then it continues, right? So that's how the dynamics with regards to human rights work. They are very hard to attain in substance. They are very hard to attain in substance. एक केस हुआ था, if you remember, there was one case with regards to the sexual harassment of women at workplace. Do you remember that case? Anyone who can recall that case? Yes, very nice, very nice, very nice. So all of you know that there was this case known as Vishakha versus State of Rajasthan that laid down certain guidelines for the sexual harassment of women at workplace that every workplace has to adhere to. What was the impulse of Vishakha versus State of Rajasthan? क्यों हुआ था वो case? Why did that happen? Yes, Subhankar, very good. So it was a Bhavri Devi. Yes, Madhavi. Subhankar and Madhavi, thank you for the response. It was the gang rape of Bhavri Devi who was trying to stop a child marriage in Rajasthan, right? She happened to be belonging to a lower caste, and she was gang raped by by uh, by men, and then the case went up to the court, and another petition in the form of the public interest litigation was filed by Vishakha, the NGO, and then it successfully got the guidelines on the sexual harassment of the workplace. Can anyone tell me, without googling or without putting it on a search engine, what happened to the rapists of Bhavri Devi? उनका कुछ हुआ? Did उनका क्या हुआ? Did Bhavri Devi get justice? Did Bhavri Devi get justice? Right? So some of you are saying acquittal, some of you are saying nothing happened. Well, 4 of them have already died without going into the prison. Initial courts, in fact, questioned Bhabri Devi's own character, right? So we can celebrate having Vishakha versus State of Rajasthan. We can quote it in our research papers and seminars like this. But then the essential human dignity of Bhabri Devi still remains violated. Till date, she has not got justice, and that is something which is very worrying. All the criminal law amendments that you would see with regards to rape over the period of time. Yes, I'm coming to that. All the criminal law amendments that you would see, you would find that they have happened as a knee-jerk reaction. So one amendment happened after the Mathura rape case. If you remember, for those of you, for the uninitiated, Mathura was a tribal woman raped by the policeman in the jail, right? And the court acquitted the culprits on the ground that Mathura was not raped because she did not shout and she was habitual of sex, and therefore, being habitual of sex, it is not possible that she got raped, right? So these are the things which have happened that led to the criminal law amendment. Then of course we know about the Nirbhaya rape case. So something like Nirbhaya had to happen in order to have the criminal law amendment again in that direction. Something like Asifa had to happen in order to have another criminal law amendment with regards to the child rape, right? So these are the things which we have to take into consideration, right? So we will have the discussion. I mean, chat is not a place to have a discussion. We will have a discussion after the session gets over. Maybe then you can express yourselves. But but the point of telling you this is that in a post-colonial state, these human rights are still very hard to claim in order to have a fulfilled life, right? Let us try to think about some more cases, right? Do you remember Nalsa versus Union of India in 2014, the Supreme Court case in 2014? Nalsa versus Union of India, what was that about? What was Nalsa versus Union of India? Can anyone tell me? the transgender case, right? That the transgenders have the equal right in the society. If you will read Nalsa judgment, you will find a very interesting fact. During the British time, there was something known as a Criminal Tribes Act of 1871. Criminal Tribes Act of 1871 was referred in the Nalsa judgment. In that act, the transgenders were treated as if they are innately criminal. That was the language used in the act, and the court acknowledged that act, saying that this has been the history of oppression for the transgenders over the period of time, where they have been treated as innately, non-adherents or criminal, or someone who is addicted. That was also the term used in the act itself, that they are addicted to to commit the crimes, right? To be non-adherents to the law. So this is how the law treated them eventually. But then fortunately we had that judgment, and I leave it on you again to decide whether after these judgments, whether after Nalsa or after other judgments, the things at the basic level have really changed or not. Are we having enough respect for the transgenders now? Are we comfortable when we are sitting in the train and the transgender people come and ask for money? Are we comfortable in that moment? Are we able to exercise respect in our mind while talking to them? Try that once, because let's say next time when it happens, they come and they ask for money, or they try to approach you in a certain way. Just try to talk them with respect and see their response. That respect is still not there. They are still shooed away. They are still looked with a condescending eye, right? So the human rights may have been established by the post-colonial state through the judiciary in a certain judgment, but then it is not percolating down to the society, right? Then there has been a judgment on the rights of marriage in the case of Supriya Chakrabarti versus Union of India. Can you tell me whose marriage we are really talking about? Supriya Chakrabarti case, very recent case. Can you tell me? Supriya Chakrabarti versus Union of India. Yes, yes, yes. It was about the marriage rights of gay couples, right? So did the Supreme Court grant that, or the Supreme Court did not grant that? Yes. So the allegation is that the Supreme Court has been a little conservative in this, and it has not granted the right to marry to the gay couple. Now, you may agree with, you can be on any side of the spectrum when it comes to, acknowledging and recognizing gay rights. But then eventually it comes down to the fact that it has been a struggle for that community as well. And so sometimes, so what has happened this time? This time it has happened that the Supreme Court has said that marriage is something which is a personal preference. It cannot be claimed as a right against the state, right? And if at all they are supposed to be together, they can be together as a union under Article 19. So you have a freedom to form associations or unions. So that union is extended to the union of the families of the gay couples, right? So Supreme Court is saying that you can live as a union, but you cannot claim marriage as a fundamental right. So this again has been one of the cases which has evolved over the period of time, especially after the Navteej Singh Johar case that happened in 2018, when people were really uh, hopeful that something would come out positive in the recognition of the gay rights. But nevertheless, that did not happen, and that still continues to be a struggle for the LGBTQ community. Again, I say that as a the marker is that you may agree with their position, you may not agree with their position, but the point of giving you these examples is to show you the trajectory of human rights, how human rights work over the period of time, how they operate, and how the state behaves with regards to the human rights, right? Now, if you remember, one of the most progressive uh, uh, enactments, uh, I think if we can name some of them, the Hindu Succession Act Amendment of 2005 that gave the co-passionary rights to the woman, the Right to Information Act of 2005, the Right to Education Act of 2009. All of these acts have been fundamental in giving the rights to the people. But then we know the status of education in India. We know the status of the Right to Information Act, how many activists under Right to Information Act are getting apprehended, or they are still, they are still not very comfortable in being the activist as as they would have imagined themselves to be. You must read about the struggle of the Right to Information Act 2005, how Aruna Roy, Nikhil Day, and their group, they worked day and night for 2 decades to ensure that we have something like Right to Information Act. Why is it a struggle? Isn't it a natural thing? Isn't it a natural thing that once we are sitting in a setting, in a democratic state where fundamental rights are guaranteed, everything is goody goody, then it takes 20 years to claim a right to information. It takes almost a generation to claim gender justice. It takes almost a generation to claim the caste-based reservation, right? So it becomes very, very difficult to really claim it. You have to fight hard. You have to exhaust your resources. You have to form communities. You have to form associations, maybe take foreign funding in order to operate in a way that can fetch you some favorable judgments, and you can really fight the cases, pay the fee for the lawyer, and all of that. So it is really a tenuous process when it should not have been a tenuous process in a democracy, right? So that's the point that I am trying to make. Now that was the part of that was the that was the Indian part that I wanted to share with you. uh, we will now make a small transition towards the international legal aspect. Like I mentioned in the initial introduction, that we will cover the Indian aspect as well as the international aspect also. So tell me one thing before we do the transition. Do you remember the case which is considered as the most important case on fundamental rights in India? सबसे बड़ा केस आपने कौन सा सुना है फंडामेंटल राइट्स के ऊपर? Keshwananda Bharati. Very good, very good. We all have it. We are all having a consensus that Keshwananda Bharati case was one of the most important landmark watershed moments in the Indian judicial history, right? The Keshwananda Bharati case is basically known for saying that the basic structure of the constitution cannot be violated. The basic structure of the constitution will remain intact, and the parliament cannot take away that through an amendment. That was the crux or the gist of the Keshwananda Bharati case. But some of you may get surprised as to what perspective Keshwananda Bharati case had for the international human rights regime. That was a national case, of course. It was decided in India by the Indian Supreme Court, but it engaged with, yes, Anukul, very nice. It engaged with something which is internationally recognized, and I want you to take a look at that. Let me share the screen with you. I think you can still see my screen. So let me take, this is Keshwananda Bharati versus State of Kerala. Let me just go there. Moderator, are you there with me?
Yes, sir.
Yeah, I'm sorry, I'm forgetting your name. You are Harsh, right?
Yes, sir.
Okay, I'm sorry, I'm calling you moderator. Bar, but yes, Harsh, can you just read this small sentence that is in front of you for the benefit of others?
Sure, sir, I will. Uh, in view of Article 51 of the Directive Principles, this court must interpret language of the Constitution, if not intractable, which is, after all, a municipal law, in the light of the UN Charter and the solemn declaration subscribed by India.
Yes. So what is it saying? It is saying that in the view of Article 51 of the Directive Principles, यहाँ पे नीचे if you will see, Article 51 says that India should foster respect for international law and treaty obligations. So, in the view of these provisions, these principles, the court must interpret the language of the Constitution in the light of the UN Charter and the Solemn Declaration. Solemn Declaration over here is the Universal Declaration of Human Rights, right? The 1948 big event in international law, Universal Declaration of Human Rights. So a very interesting thing about Keshwanand Bharati is not really explored in our classroom discussions. In our classroom discussions, usually the discussion is with regards to the fact that the basic structure cannot be changed. But then look at this observation of Judge Sikri in this case, Keshwananda Bharati versus State of Kerala, that the language of the constitution must be interpreted in the light of the UN Charter and UDHR. So if I ask you, where is the court placing the international law vis-a-vis the constitution? Is it placing it a pedestal above the constitution, or parallel to the constitution, or beneath the constitution? Where is UDHR or UN Charter located according to the court? Yes, Sangeeta. Thank you for the response. Because let's say if the constitution is supposed to be interpreted in the light of some other text, then that text has to have a bigger sacrosanctity as compared to the constitution. To some of us, this can be an uncomfortable idea to think that as a the constitution is the supreme document, and we cannot really say that something else is over and above it. That can be true as well, but then this is an observation of a judge of the Supreme Court of India deciding one of the most famous landmark cases in the Indian judicial history, right? So that makes it important for us to really look into the international human rights regime, how that has worked, how it has evolved over the period of time, right? And how has the struggle been over the period of time, right? I want you to consider this. I want you to consider this case. Harsh, can you tell me if you can read KL versus Peru on the screen? Can you see
Yes,
this?
sir. Right. It's visible.
Yes. So I just want you to have a look at this case, and I just want to share something about this case to you. Uh, KL is, of course, an abbreviated name. It's a codified name. The identity of the victim is not released. KL versus Peru. Peru, of course, is a country. Now, the interesting dynamics in this case that you can see on the screen is that there is an individual suing a state in the United Nations Human Rights Committee. So that is, equivalent to a person A suing a state X of which he is a citizen, right? So KL was the citizen of Peru. She took Peru to the United Nations Human Rights Committee and took the compensation from its government, from the United Nations body. Now KL was whom? KL was, she was expecting a baby. The diagnosis found out that the baby will not be normal. He would have some deformities that would be not sustainable for the mother. It would be mentally traumatizing for her. The baby will not survive. She went for abortion, but the Peruvian authorities did not allow the abortion to her. She went up to the best courts in the Peru, but all of them denied the abortion rights. The hospitals denied the abortion rights to KL. Finally, the baby was born. She went through all the kind of traumas that a mother in that situation can go when a deformed baby is born. And then she took her state to the United Nations Human Rights Committee and said that, I need a compensation for this. And the UN recognized the right of an individual against its state. So, so this kind of an arrangement seems to be breaking the hard clutches of the post-colonial state that I mentioned about in the beginning. The post-colonial national state, remember, the post-colonial liberal state, or the post-colonial developmental state, right? So that is something that we have to take into considerations, that international law has the power to really transcend through these post-colonial state ideologies and do justice at the international platform, right? So this is one organ of the United Nations that has been created for individuals to approach, and they can take their states and get the compensation or the relief that they are seeking, right? It is just that since most of the international law is treaty based, a lot of respect for sovereignty is there in international law. So only those states who have signed this optional protocol to the International Covenant on Civil and Political Rights can actually, you know, the citizens of only these states can approach the UN Human Rights Committee and get the relief. As far as India is concerned, India has not signed the optional protocol to the International Covenant on Civil and Political Rights. For the uninitiated, let me just tell you that International Covenant on Civil and Political Rights is one of the most celebrated international human rights document alongside UDHR, and there is one more brother or sister, you can call it, to this covenant, that is known as International Covenant on Social, Cultural, and Economic Rights, ICSCER, right? So all of that is there. So these are the things that you can consider, that there are international legal platforms now for the states, for the individuals, I'm sorry, to get a relief whenever they feel that their human rights needs are not getting met by their states. I don't know how you see it. Do you see it through a nationalist perspective, that how is it possible that a citizen of a country can take his own nation or her own nation to the UN body? That is almost being a traitor against the state. That is one thing that you can think of. You can also think that, all right, so we are one community. We believe in Vasudhaiva Kutumbakam, where all of us are together in this. So if someone is getting racially discriminated in the United States of America, if the children are dying somewhere in the West Asia, then we feel that pinch, we feel that pain, because we share not just the national bond, but we also share the human bond. I just want to share with you two more things. When I talk about human bond, just to get you started in that stream, I want to share the opening lines of the UN Charter. Let me take you over there. Can you see UN Charter, people?
Yes, sir.
So if you remember, the Constitution of India starts with "We the people of India," right? So we the people of India being belonging to the Indian state. How is the United Nations Charter starting? And by the way, of course, India is one of the founding members of the United Nations, right? We the peoples of the United Nations determined, right, that we will save our generations, we will reaffirm faith in fundamental human rights, in the dignity and worth of the human persons, in the equal rights of men and women and of nations large and small. So that's what I am saying, people, that let's say if the post-colonial state is operating in a certain ideological sense, and that happens to be not a very broad-based ideology, it is a narrow ideology, then in that case, one of the remedies that can be offered at other forums is actually the international legal forums. They are the main places where people are going. People can go to some extent. The international law in that direction is still evolving, but we never know what shape it would take. Now, when Kalpeshji called me for a session on human rights in one of the earlier, sessions of this kind of a program, I shared with the students a document that I had prepared with regards to the international legal platforms that are available to address the human rights needs of the individuals. Right. So one, we just saw the UN Human Rights Committee. The other, I want you to take a snapshot of this, and this was prepared with a lot of labor. So I hope you will find it useful. So all these forums that you can see, right? The International Court of Justice takes up the matter of the human rights. An individual cannot approach the ICJ because it is essentially a state-centric forum, but nevertheless, it does listen to the issues of human rights. We just saw UN Human Rights Committee. Then there is European Court of Human Rights. Then there is Inter-American Court of Human Rights. Then there is an African Commission on Human and People's Rights. Then, of course, there is International Criminal Court. You can take a snapshot of this, do your analysis later on, try to imagine what has been the trajectory of international human rights dispute resolution alongside the national human rights dispute resolution as we have witnessed in India over the period of time. Right? So, and of course, to put it in the as a concluding remark, when we are discussing human rights, whether at the international level or at the domestic level, we must understand and we must keep it in our heads that only those human rights acknowledgement are successful or should be considered successful which are translated on ground. Otherwise, it remains, a kind of a declaration which everyone can morally look up to, but nevertheless, it is not having a substantial impact on the field. So the real success of human rights will lie in that direction. So that's it from my side, Harsh and Kalpesh ji. If there are any questions, there's anything that anyone wants to ask, I will be attempting that as well. Thank you so much.
Thank you, sir.
Yes.
Participants, please drop in your questions in the chat box, or you may also raise your hand and we'll unmute you. So the first question we have is from Mr. Satyam Sharma.
Mhm.
He asks, can we inculcate the study for gender in our education system? And will it help to change the mindset of the upcoming generation towards the LGBTQ plus community?
Well, of course, those options are there, but I don't know. Would you treat it as a sociological issue? Would you treat it as a legal issue? Of course, when third gender is discussed, let's say in cases like NALSA, it becomes a socio-legal issue. So I think one of the good ways of dealing with these kind of progressive thoughts that transgenders have the equal rights like any other gender. So that can make a good part of the honors courses, right? In the honors courses there can be a separate paper where we can discuss all these progressive developments that have taken and the philosophy behind these developments. My sense is that not everyone gets to read law, so it would make uh, 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 it would be, I think, a better idea to have these kind of informative sessions at the school level itself when the students are let's say reading political science or history or sociology or whatever, even science students, there should be some curriculum that talks about the human side of the society as well, so that people are aware that, they're conscious that these kind of rights also exist, this kind of sensitivity also exists. So yes, not just in the universities, I think even in the school systems we should be sensitizing the kids about it.
So the next question is, how can law students and advocates help in matters related to human rights?
uh, well well, advocacy is one of the best thing that you can do, because you are getting trained in that. Of course, 5 years of training or 3 year of training, whatever you are taking, you are preparing yourself to become lawyers. And I think one of the good cases can be to look up to can be the Shreya Singhal versus Union of India case, where Shreya Singhal successfully convinced the court. She was a law student, if you remember. She successfully convinced the court that Section 66A of the Information Technology Act, that gives arbitrary powers to the state to control what you post on your social media, should be struck down. And the court actually declared it unconstitutional. So that is the impact that you can have as a law student. I mean, I had law students at Bennett University, at Galgodias University, who have been filing PILs. So PILs, to file PILs, you really don't need to be registered in the bar, right? So yes, you can make a change in that direction. Not very difficult. Yes.
So the next question is, how would you put the responsibility of human rights violation for the COVID-19 breakout?
Human rights violation for COVID-19. Well, COVID-19 had lots of dimensions uh, to it. So one was the migration that we saw. I mean, we have Supreme Court judgments on that. Uh, Migration, as in the movement of the people on foot, then those disinfectants being sprayed on the people. Those visuals are also there. Then there was an allegation on the Muslim community, that Muslim community, or the Tablighi Jamaat part of it, is propelling COVID-19 for some ulterior motives. All those things were, either manufactured or people saw it happening. uh, so during COVID-19 breakout, one of the things that was a lot of interest to me was the debate between personal autonomy and the public interest. So there were people who were really getting, uh, they were not very comfortable with vaccinations. They said that this vaccination is problematic. I have heard reports saying that people who have got vaccinated, they die, and therefore I will exercise my individual right, my freedom of having an informed consent, to really not volunteer for this. You cannot force me. You cannot say that I will resume my employment only when I am vaccinated. So that was the personal autonomy part, which was pitched. I don't remember the name of the case, against the public interest. But I think the Supreme Court ruled in favor of public interest, saying that whenever there is a clash of personal autonomy against the public interest issue, then in that case, the public interest should prevail. And I think that made sense in that moment of frenzy that we had during COVID-19.
So the next question is, the imposition of laws by authorities is a top-down process, whereas the acceptance of laws by the society is a bottom-up phenomenon. How do you link these two, and how do you think these influence the effectiveness and the legitimacy of the legal system?
And that's what we have been discussing since last 1 hour. That we have the laws, we have the judicial decisions, but they are not necessarily reflecting as a social reality. There are, Dalits getting flogged, people getting lynched, and there are instances of terror, there are instances of rape happening, there are instances of child abuse happening. all those things are happening still, and I don't know how much of those laws or those judicial pronouncements are having a real time impact. I think one of the things that Supreme Court should seriously consider is the kind of impact that its judgment has on the society. And there has to be a robust review mechanism for, let's say, if the Supreme Court is saying that there cannot be a sex selective abortion, there cannot be a prenatal diagnosis to determine the sex of the child and then abortion after that, just in case if it happens to be a girl. So it gave a very strong ruling in Sehat case, but then don't we know that that is still happening in the clinics today. The sex recognition is happening, abortions are also happening, our sex ratio is skewed. Now it is getting better, but in large parts of the country it is still skewed, let's say in the states like Haryana or other places. So so there is a disconnect between what Supreme Court thinks and what actually happens in the society. One of the ways to do it is what Supreme Court does in some cases, that it calls for a review. It calls the state to submit the status report, that what have you done in a particular direction when we have given a decision. I don't think, as far as my knowledge goes, much of that kind of a review is happening as of now. Yes.
So the last question for today. How do you look at the reservation policy of India in comparison with other countries?
See, it depends on the dynamics of your social structure. So, one, let's say, if you have read the United States history, I mean, it's a racial history, and there is one very famous case of the United States, Brown versus Board of Education, in which before this case, what used to happen was that blacks had a different school, whites had different school, and the condition of blacks schools were quite dilapidated, very bad. The white schools were comparatively better off. Then there was a litigation in the court that why should there be this kind of segregation between the blacks and whites. So finally, the court said in Brown versus Board of Education that separate cannot be equal, right? So that pronouncement ensured that the black community reads in the school classes along with the white community in the same setting, in the same classroom with same facilities. Those dynamics are peculiar to the United States. Our dynamics of affirmative action are different. So we have vulnerable groups like castes, like women, like children. We have our own social stratification, and so that is why perhaps we really give all the credit to Dr. Ambedkar, who has been the avant-garde in really taking the human rights cause and the oppressed classes claims to such an extent that today we have some kind of a nominal justice to these oppressed sections. So yes, that's how I see it. It's dynamic perspective. It varies from state to state. States have different societies, different structures. So justice is done according to that.
Thank you so much for answering all the questions, sir. Now I invite Dr. Kalpesh Kumar L. Gupta, the founder of ProBono India, to deliver the vote of thanks.
Thank you very much, Has, for. Hello, am I audible?
Yes, I can hear you.
Yeah. Thank you
Yes,
very
sir,
much.
please
I
go.
would like to take a couple of questions. Like there are questions I can see human rights and AI, and the rights of the criminal. What about their human rights? Will it be lead to more crimes? Would like to take, and then sorry for, yeah, over to you.
Rights of the criminal.
Human rights of the criminal. Will it be like it will be leading to more crime? So talking about human rights of criminals, will it be lead to more crimes? And the second one is AI and human rights. Two questions I'm putting before you before I close. Over to you.
No, I think despite becoming a criminal, the person remains a human, and you know, we also have to consider there's a lot of talk about uh, the 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 psychoanalysis of the criminals. So, for example, let's say if someone has done an act of theft and you simply punish that person, despite the fact that he was in dire poverty and the state failed to provide food to that person, the ration scheme did not reach to that person, his family was dying out of malnutrition, and he stole a bread from someone. Would you treat that person in the same way as you would treat a theft a thief who has really committed it in a criminal sense of the term? So sometimes a lot of indictments that happen in the criminal law, their background checking is not a part of our legal system. So when they are there as a part of the prison system, of course, human rights are supposed to be extended to them. Otherwise, we would not, we would be behaving in a very tyrannical way. And I think that's something which is a part of the extradition treaty arrangements between the states as well. So let's say one of the reasons why it took so long, it is taking so long for the government to fetch Vijay Mallya from the United Kingdom, is that United Kingdom, Vijay Mallya is saying that prison conditions and human rights conditions in India in the prisons is not good. So therefore, I will not go. So he's not saying that I have not committed the crime, but then the larger international perspective is that even if you're putting a person in a prison, you are supposed to have certain etiquettes of putting him in the prison. जब हम war करते हैं, when we are at war, I mean, if there is an enemy in front of us, we are supposed to treat that enemy in a certain way as well. That's the humanitarian law, right? So if we are supposed to behave in a certain way towards our enemy, of course these are our own citizens who have just uh, gone in a different direction. And then of course there are different theories of reformation of these criminals. That can be a separate debate altogether, but we cannot really take away the human rights angle from the criminals. And I think if we treat them with respect, it would be having a transformative effect on them. So this is one thing. And what was the other thing, Kalpeshji, that you said?
AI and human rights.
AI and human rights. Yes, it's a big issue, and most of it is coming actually from the racial profiling point of view. So a lot of coding of artificial intelligence is being done in the Western jurisdictions, right? And a lot of coding is also done by white people in English language, right? And so the AI system behaves in a certain way. Then there is an issue of accessibility. How many of us would really have an accessibility to AI systems, right? So Harsh and I and you and others over here can use ChatGPT, but how many others are there in India who can use ChatGPT? जिनको पता भी होगा ChatGPT का ये purpose होता है. So we would propel ourselves using the technology to better horizons, but those benefits would not reach to others as well. So accessibility and profiling are the two things which are really problematic when it comes to AI. Of course, the third thing is with regards to privacy. What we share on our social media, the data that we share on our social media. So privacy has emerged as one of the fundamental human rights in today's times, because data is said to be gold in the modern times. And the way in which we can be manipulated by our data theft, it is unimaginable, right? I'm sure that it has happened to the audience over here at some level, that you're discussing about, let's say, chips in your drawing room discussion, and then suddenly some ad of chips come on your mobile phones. It's just a mere discussion, but then it features on your mobile phone out of nothing. And you are just saying that We were just discussing that this, and it is just featuring over here. So to what extent your data is fetched and to what extent your behavior is manipulated on the basis of that fetching of data is something which really impinges upon your privacy. So privacy, profiling, and what was the third thing that I said? Privacy, profiling, and can anyone repeat what was the third thing? Third thing? Accessibility. Yes, accessibility. So these are the three things which we have to consider when we talk about AI and human rights.
Okay, so thank you very much for responding these last couple of questions. I'd like to thank on behalf of organizing committee for this wonderful lecture. I would say this is equivalent to 10 to 15 lecture that discuss so many things. I think this I used this statement earlier also because it's very humongous task to discuss human rights within 1.5 hour. So in the grateful to you that you are since there with our course discussing this human rights aspects with related to legal aid. And I hope participants got some idea, right, how to connect with legal aid, human rights. Again, day-to-day things keep coming. How you correlate those things and take initiatives from your end wherever you are as a student, faculty member, or professionals. So thank you very much once again, and look forward to you in future also. Thank you very much.
Thank you so much, Kalpeshji, and I congratulate you and your team, Harsh and his team, and everyone over here. I don't know if there are students from Merit University over here, but if they are there, hi to them as well. So, so
Lakshmi
do
is
well,
there.
and thank you so much. Nice having you. Thank you.
Thank you.
With this, we wind up the session for today. Until we meet again tomorrow. Thank you everyone for joining.